Morning, everyone. We're collected for our October 10th, 2024 Environmental Control Board meeting. I'd like to call today's meeting to order. Thank you all for being with us. And Madeline, would you please conduct roll call to verify quorum?
Yes. Commissioner Rickmont,
Present.
Jamonda Graham,
Present.
Joseph Gregory, Elizabeth Nauer, present. Madeline LaGuerre,
Present.
Russell Cunis,
Present.
Arminder Paul
Present.
Matthew Sheed,
Present.
Thomas Spetner, Matthew Smith,
Here.
Douglas Swan,
Present.
Lisa Urban, here, Jared Whittington. We have a quorum 10 out of 13.
Okay, thank you very much. We'll start with going over some minutes. And let's start with the August 1st, 2024 meeting. Does anyone have any edits or corrections to the August 1st minutes?
I have a ministerial suggested edit. Under agenda item number 1, there's a notation in the minutes that says that the motion was erroneously passed. And then it goes on with the saying a new vote will proceed. Before it says a new vote will proceed, there's a bracket, open bracket. I'm just suggesting we move that open bracket up to right where it says the motion was erroneously passed, because that language, the motion was erroneously passed, was not actually discussed. It's an internal notation. So all I'm saying is, like, let's move the bracket up and then add a sentence that say the motion was passed. So historically, we took a vote, the motion was passed, and then open bracket saying, by the way, it actually didn't pass, and we will end up revoting. Any questions, concerns? Make sense? Okay, so that's my one comment. Objections to that edit? No. Okay, with that change, can I have a motion to adopt the August 1st, 2024 minutes? Okay, we see a motion from Elizabeth, a second. Okay, second from Madeline. Can we take a vote, please?
Okay, are there any objections to the motion adopting the minutes of the August 1st, 2024 ECB meeting?
Okay, one abstention. Yeah.
Right.
Oh, yes, that's not present. Neither will I, actually.
Okay, so we have 4 abstentions, but we have enough to pass those minutes based on who was here today and who was here last time. So besides the abstentions, seeing no objections and noting the abstentions, the motion is approved.
Okay, thank you. All right, we'll now move to vote on the June 13th, 2024 board minutes again. These were adopted at the last meeting in error, so we're just going to revote. Does anyone have any edits to the content of the June 13th minutes? I do. The lawyer in me also just had a light ministerial edit. If we go to agenda item 3, that technically, and it says we return to public session, but it's lacking the language that says we went into executive session, which we normally. So just adding a note at the start of agenda item 3 that the board went into executive session, and that'll round it out. Leave executive session. Any objections? Okay. I'll give you. Any, can I have a motion to adopt the June 13th, 2020 meeting minutes? Okay, I see a motion from Matthew, a second. Second from Arminder Paul.
Okay, are there any objections to the motion approving the June 13th, 2024 ECB meeting minutes?
I'm still abstaining as well.
Okay, so that's Lisa and Elizabeth abstaining. Anyone else?
Based on the attendance from last time, I have enough to pass. So seeing no objections and hearing no objections, the motion is approved.
Good, thank you, everyone. Okay. We're now going to move on to the introduction of a resolution regarding the board's delegation to hearing officers authority to remit a civil penalty under Administrative Code Section 244B. This is a matter that we previously discussed And I'll turn it over to Acting General Counsel Frank Eng to explain what's in front of us today and some of the background.
Good morning, Chair. Good morning, board members. I have two sets of handouts relating to resolution.
What is everything?
One is the resolution from three, and then the email resolution was when we have received.
Yeah, you would have received before, in prep for today's meeting, you would have received the October 10th version and the August 17th, Frank is circulating as a courtesy note.
The October 10th is the one you emailed, so.
Right.
Okay.
So we should have an October and an August.
Correct.
So relating to the new resolution, just a recap. In August 17, 2023, the board had passed a resolution directing the hearing officers to impose a zero penalty in Administrative Code 24-244B cases, those involve sound production device violations, where the respondent was no longer in violation at the hearing. On June 13, 2024, a New York Supreme Court justice held that the resolution was impermissible as it mandated action by the hearing officers and nullified the resolution. The resolution is at this point not in effect, and we would want to propose the new resolution that would provide the hearing officers with the discretion to remit in whole or in part the penalty relating to section 224-244B if found not in violation of the hearing. So the difference is that the board delegates their authority to remit in whole or in part for this new resolution, whereas the prior do not allow the hearing officer that discretion. And this would not be rulemaking, and we do believe this is legitimate and pass.
And just to add, if it's not clear from what Frank was already saying, the October 10th, 2024 version corrects the issues that the court found with the August 17th, 2023 issues. We think that it will make sense.
And yes,
So now we're giving them the authority to have a zero or other penalty.
yes, they can choose to remit, not remit, or have a range between those two units.
So this is only in cases where the conditions have been
Correct.
Sorry, just as a reminder, the reason that the court found on the prior resolution to be inappropriate was because it found it should have been subject to rulemaking, right line directive.
Correct, because it didn't provide for discretion. It was a mandatory action based on certain circumstances, and that would require.
And one of the key pieces being the word shall at the end of the August 17th, 2023.
So the discretionary basis of this new resolution would solve, in your view, the issue that the court raised.
It would. Basically, you are delegating your entire authority to either impose a zero penalty, a full penalty, or something in that range. And just to inform the board, current penalties for this particular summons is $440 for the first offense, $880 second, and $1,220 for the third offense. However, just to check the data, we've had this year one violation in January, one violation in March, 23 in April, and none since. So for the whole of 2024, we've had 5 violations.
And that's because of the reduction in the year now that's.
It's
Correct.
the,
That might be a reason. Exactly. We don't know the actual cause, but you know, one could surmise that changes in the structure of the program have led to such cases being introduced.
Based strictly on technical poorly.
Are we gonna know if, one of the things we were trying to protect against and we were concerned about was an establishment getting multiple violations before we get notice of and possibly a citizen claim taking advantage. Are we gonna get a report in the next meeting, or can we get a report in the next meeting or two, just seeing how this all plays out?
place out in terms of whether
I want to, but what I don't want, what I think we're concerned about, what I personally was concerned about is we're seeing a lot of violations on individual establishments in short order where they're getting giant fines and they didn't even have knowledge of these fines. So I'm just asking the question if we can understand how this plays out. If you just gave us this report about the fines and the money going forward, if we can kind of see how our recommendations play out in the future with the administrative agents.
So there's a few different separate issues there. If this resolution passes, we can see, since it is a manageable number of cases, we may, I don't want to promise, I need to talk to a team, but we may be able to determine how often hearing officers apply this.
Right.
Once they're informed about it. That is one issue. There's a separate issue, which people have raised concerns about, which is the phenomena of businesses and respondents receiving, multiple summons on the same day for what might have been activity over 3 different incidents, as opposed to within 10 days of the first incident getting the summons, then, et cetera, it's spread out over time. That is not, that won't be dealt with by this.
Right.
That is an issue more of the requirements of the program regarding, are there deadlines around which a summons has to be served within a certain period of time after the alleged violation. And those are things that will go through either a rulemaking process or legislation outside of that would be at the enforcement agency level or city council level.
Just to, like, I do think this helps address that concern in the sense that the hearing officer would have discretion to impose a 0 or lesser penalty if at the time of the hearing, the establishment is in compliance. Because even though they've been, sort of issued all of these summonses at once, they wouldn't necessarily have to pay penalties on them if they show that they're in compliance.
That's a fair point. That's correct. Yeah.
So it could help solve that problem by giving the opportunity, giving the discretion to the hearing officer to sort of recognize the mitigating.
That's completely correct. That's right. And maybe that's what you were getting. I may have misunderstood the point, but thank you.
I think we're going to find out pretty soon if you can track the things in the next meeting or two. We'll have pretty good data whether or not it's being effective.
Yeah, and we'll, based on the current trend, we're not even seeing many of these cases, but we will look into whether we can capture how many times we see the hearing officers applying what would be their new authority and passage.
So if I understand correctly, the hearing officer has discretion, which means he or she is not required to impose a 0 penalty, which likewise means that they could, if they chose, impose it. Do I understand that?
that's correct, they can impose a full penalty should they choose.
So is there, I know the hearing officer has to have their discretion, but is there any concern? I have concern about decisions being made, sort of like not consistent. So is there anything in place, or are there any plans to put in place? I know you can't tell them how to decide, right? But I am worried that in one instance, a person may have a penalty and then a different respondent, hopefully, but in similar circumstances could have a 0 penalty. Are there any steps being taken to avoid that?
So it's a fair concern. So the law gives the board the authority to do just what you were saying. The authority is there, and so it would be the case that if we were all sitting and reviewing all these cases, would we also have issues around consistency or not? So we're just taking that same power that the board has here and giving that to hearing officers to decide. Are there current structures in place that could help deal with that? I'm not aware of any. We have to leave it to the discretion of our hearing officers. That's what decided today. If that's a concern, like that would be a reason not to pass the resolution. But the other thing that we're seeing, and we can keep an eye on it, is just a resolution. Resolutions can be pulled later. If such concerns arise in the future, we could revisit this, and that comes back to Matt's point about trying to resolve cases. Yeah. It's just-
So, obviously, when the appeal process, we worry about just the answers as far as it really consistent with the appeal and use in prior cases since the, you know, Senate board.
Yeah, this resolution, the board still retains the authority as well. So on appeal, the board could still remit if it chose to. And the hearing officer did not.
I have a bit of concern about that because if we, as a board, when the matter comes up, we have to look at the hearing officer's decision based on the information that was presented to the hearing officer at the time. And credibility holds a lot of weight side. So I am a bit, I still have the same concern. I'm open to looking at it, watching the numbers, but I don't necessarily satisfied decision on that.
So I think first thing is that between the resolution and bill that the council passed with the $50 penalty, that what we've seen is that this has basically eliminated the financial incentive for the citizens to submit these complaints in the first place, which is why they basically kind of gone down to almost nothing. In terms of the qualifying for the zero penalty, in most of these cases, what you would have to show to the hearing officer is that you took the speaker and moved it inside. It's not a major, you wouldn't have to hire a contractor to do it. You just literally have to pick up the speaker and put it in your store instead of having it out on the sidewalk. So I don't think this is gonna be a major, like, difficult finding for the hearing officers to conclude one way or another. Either they're gonna find the respondent's statement credible that they put the speaker inside, or they're not. So.
And that may result in
But that-
differences on.
Yes, and that's my exact point. They can find them credible. And it comes to the board, we routinely decline to overturn a credibility finding unless we have something. Right?
Yeah. So, Lisa.
So this is specific just to the noise, these noise violations. Do the hearing officers have this kind of discretion for?
No,
So how come we're giving it to them for this?
Because the law only gives it to us for this.
Okay, and in other situations, they already have it?
So in terms of the board authority to remit to zero, and we'll turn to my colleagues to see if we have that authority as a board outside of the noise.
outside, well, the noise code gives the board the authority for all the noise code provisions. The reason is the board did not see a reason to delegate that authority for any of the other types of violations, which are generally issued by DEP. So DEP has gone in and done an inspection and has determined, so there's a fixed penalty for those.
And not, but it's not in like the air code, et cetera.
It's not in the air code,
Right.
it's a noise code, but there are other noise code provisions that are issued by DEP.
Right, and then I think as a historical matter, Lisa, there was a specific discussion around these cases because of the circumstances last year when we saw as volume. It's an interesting question, should this be broader and extended to other provisions? My own personal view is since we're doing this now, we're talking about monitoring it, maybe we keep it limited and monitor it and then see if it's something that we want to expand to other provisions of the noise code. But that's just one point of view.
Right, I'm just wondering if this opens the door to, to something else that we don't necessarily want that door open to. Or if it could make it objectionable because this is the only one that applies. Is it, you know, in some sort of theory?
That's a fair question. You know, is the fact that it's narrow itself, going to make it subject to scrutiny? Any concerns?
I mean, to the extent that the board has discretion to review this, if this requires an additional resolution or another avenue in the future, then we can vote.
Any other comments?
I think that the reason that we embarked on this concept was a particular reason that applied specifically to these citizen complaints. And therefore, I think there's a rational reason to address these types of violations specifically as opposed to general rights violations that are issued. So I think there's a good distinction.
One last one.
Yeah, sure.
So if this is likely to result in a reduction in the number of suspicious citizens, are you guys going to enforce point based? Because in some cases I know that this is largely driven by the citizen. And you have a small concern that in cases where there does need to be enforcement, would you guys go out to do because you receive the complaint?
We respond to 311 complaints. These are not 311 complaints. These are people wandering up and down Roosevelt Avenue with their phone, taking a video of every business that has a speaker outside that nobody is complaining about. So these are two completely different, what we enforce with our inspectors and the way the citizens do the enforcement is two completely different.
Understood. But my point is, so if DP did get a complaint, which you're not getting down again, your inspectors would go out and.
As we normally do, and if we found a violation, the business would be informed that they were in violation and would therefore have the opportunity to move the speaker off the street, which means they would not get another violation in the future. What the citizens were doing was that they would go back to the same business every day. They would video it every day and they would not tell the business. And then because we don't have the bandwidth to review the noise complaints, because we're getting 100,000 idling complaints a year, these go to the citizens to self-enforce, and the citizens would self-enforce by putting 20 summonses in the same envelope and sending it to the business, meaning that the business was going to be subject to 20 times 440 with no notice that they were ever in violation in the first place.
All right, any other comments or questions? Okay, can I have a motion, for vote on the resolution? Okay, motion, Elizabeth, the second, from Joseph, okay. Please take a vote.
Are there any objections to the motion approving resolution? Seeing none, the motion is approved, or the resolution is approved.
Okay, thank you, everyone. That's a very informed discussion. I appreciate it. That's what we're here for. Okay, we'll now turn it over to Russ Kunis from DEP for discussion regarding cease and desist orders. And as hopefully all of you recall, this is part of a package of cease and desist orders relating to oil that we've been discussing at the last few minutes. Russ, I assume that today's discussion, whether it's one that's outside of that package.
Additional one.
Good, okay, well, take us through. Thank you.
So I can do that one first, and
Yeah, let's
the other 9, or I could do the 9 first, and, okay, why don't we do the sewer related one first? This month, DEP has a request to the board to issue an order to cease and desist for Hutong NYC LLC at 731 Lexington Avenue in Manhattan. So Hutong is a Chinese restaurant that is located in a large office building. This is a large office building. They're located on the ground floor. According to their website, which I looked at, you can experience the splendor of 1920s Shanghai by going there. And they were issued an order a little bit more than 2 years ago to install a number of grease interceptors, which are on the second page of the package. Those are laid out in item 1, A, B, C, and D. And this was based on an inspection that was done in July of 2022, pursuant to which they were issued a commissioner's order. The commissioner's order is on the 4th page and 5th page of the attachment. When there was no compliance with the commissioner's order, a series of summonses were issued in December 2022, May 2023, November 2023, February 2024. In response to the February summons, during the inspection, the restaurant stated that they were seeking proposals from companies to have the grease traps installed. Another inspection in May resulted in another summons being issued, and they reiterated that they were still looking for a contractor to come into compliance. They were still not in compliance in September, so yet another summons was then issued, and they were notified that they were required to come to, well, actually, no. So that was actually the last summons, was returnable in, go to the actual way the summonses are. They were found in violation on the initial summonses, and then I believe on the last two, they default. That's correct. 3 in violation, and then I think the last 2 that were up for hearings most recently on September 5th. The last 2 have defaulted. So since we've issued this series of violations for not complying with the order, they clearly are aware that they need to comply with the order, since they've represented twice that they were looking for someone to hire to comply with the order, and they are still, as of this date, not in compliance. The EP is requesting that the board issue an order to cease and desist.
Any questions?
Just, and I presume that if the order actually to be executed, sealing, that would only be to the water surface of the.
Yes.
Right,
But
right.
not cut off the whole office building. Only be to the restaurant.
Let's deal with this one individually. Can we have a motion to vote on the cease and desist order relating to Hutong New York LLC? Okay, we have a motion from Matthew, a second. Madeline?
Are there any objections to the motion approving the cease and desist order for Tom New York LLC? Seeing none, hearing none, motion is approved.
Great. Thank you, Russ. Would you like to move on to the package?
So you want me to do the names, respondent names and addresses for the record?
I think so, yes.
Okay, so DEP also has 9 requests for cease and desist orders. This is the last batch of 3. We've had several of these at each of the last two board meetings. These relate to buildings that have expired certificates of operation, to use number 4 fuel oil. The use of number 4 fuel oil in boilers is no longer permitted as of July 1st of 2027. Each of these buildings has an expired permit to use number 4 oil. Since the permits are good for 3 years, they can no longer renew the permits to use number 4 oil. And so each of these buildings has been given between 2 and 4 summonses for having an expired permit for the boiler. And so these cease and desist orders will be an attempt to get these buildings off of number 4 oil and to switch to number 2 oil, or if they can, natural gas, but we don't think any of them are going to do that. This again, there have been 2 previous batches of these, so I don't know if anybody was not at either of those meetings, but there was a presentation in June. And I can just run through the respondents and the premises. So we have Creston Hills Place 26 LLC, which is at 2298 Creston Avenue in the Bronx. Audubon Property Group LLC, which is at 520 Audubon Avenue in Manhattan. GTTG Broadway at 3544 Broadway in Manhattan. 140th Street LLC at 619 West 140th Street in Manhattan. Andrew M. Duclair, who is the owner of 476 Clinton Avenue in Brooklyn. 115-123 West 29th Street Corp. For 115 West 29th Street in Manhattan. Mid-Bronx Senior Citizens Council, Inc. at 1125 Grand Concourse in the Bronx. I should probably say a word about that one. I'll just circle back to that one quickly in a minute. Pan Am Equities at 132 East 45th Street in Manhattan. And Zanshin Realty LLC at 515 West 170th Street in Manhattan. Just to circle back on the Mid-Bronx Senior Citizens Council, because of the name, we did a little extra research to find out what they actually do at this location. This is not an apartment building like the rest of them. This is an old historic building that has in the past been used as a senior citizens residence, but is currently being used as an art space and cultural center for the Bronx community. So no one is living here anymore. And there are historical reasons why it wound up being owned by something called the Mid-Bronx Senior Citizens Council, but it is not a senior citizens residence in any way.
Thank you. Any questions for us? Lisa?
So you're gonna seal the boilers, which basically means that these buildings are not gonna heat, right?
If we had to seal on any of these, the building would have to resort to getting a temporary boiler.
But just to clarify, in terms of sequence of events, if we vote for the cease and desist order, they receive the order. That's not an automatic sealing.
No.
They would have a hearing.
That is a notice
Oh,
to
okay.
appear.
All right.
Notice to appear a hearing in which they could. And now this actually comes to a question I have, Russ. Since many of these have inspection notations that the inspections are from January, from months ago, there is a possibility despite the records that you have at DEP, that someone has remedied the situation, they just haven't told anyone, maybe? So at a hearing, they'd be able to say, wait, we did fix something?
Yes, and also at a hearing, they would be able to tell the hearing officer that they had hired a contractor to do the necessary work, in which case it would be normal for these to be given adjournments in order to come into compliance. The purpose is to get them into compliance. So far, we've had the hearing date on the first batch that was approved in June. And there have been a mixture of people that have shown up and gotten adjournments, people that have rescheduled their hearing dates, and a few of them have defaulted. So now we have to kind of consider what to do about the defaults. But this, we feel, is the best way to kind of have some kind of leverage to get these buildings to come into compliance. And as you can see from the second page on the bottom of the violation history, the permit expiration dates on many of these buildings are not recent.
But yes, I do see that. Other, yeah, Matt?
I'm fine with what we're doing here, but I just have a related question. I assume as we go forward with this and the process of transferring people, we're gonna start to get hundreds, not thousands of these. Is that what we expect?
I wouldn't expect that many. I think in the presentation that was at the June meeting, there were a couple of thousand, more or less, people that have permits still to use number 4. But many of those people have perfectly fine current permits, which will expire sometime between now and July 1st of 27. And when they renew, they will not be able to renew again to use 4, so they will have to convert at that point. And if they don't, if they let their permits expire, then what we would do is go through the process of giving them summonses before it would ever come to the board. I would anticipate that over the next 3 years, there may be a trickle of these that come to the board. These 3 groups totaling about 40 were just buildings that they sort of identified as priority because of the length of time that they've had expired permits.
Got it.
And I think we talked last time, you had informed us that for all of those current buildings that are operating under valid permits with number 4, who will eventually have to convert, it sounds like the agency is doing outreach and communication.
Absolutely.
You've got a 2-year runway here once you start getting convert.
They are being made aware that they will not be able to renew again to use 4, and that when their permits expire, they will be required to convert to 2.
Good questions?
Yeah, I have more of a general question. Inspectors, are they assigned, DEP, are they assigned specific inspectors for each borough? How does that work?
There are, so boiler inspections is a specific unit. And I believe that the boiler inspection unit does, inspections throughout the 5 boroughs. They may be divided up into squads, to hit certain areas of certain boroughs. But boiler inspections are done by a specific unit that has specific training to do boiler inspections. The inspectors that like respond to odor complaints or something like that are a separate group. The boiler inspections is a separate unit within the bureau.
Well, you asked that. What do you ask?
Why? Sometimes I look at the violations and where they are.
Yeah.
They're clustered in certain areas. So I'm just curious how that.
Well, a lot of this, for example, when we had the map at the presentation in June, the buildings that have permits to use number 4 are really overwhelmingly in the Bronx and in Upper Manhattan.
And that makes sense.
Okay, other comments or questions, Mike?
One question. So you mentioned that the respondent will be given an opportunity to have a special hearing where they could present to the hearing officer either reasons to not have the boiler sealed or some mitigation steps that they're taking. So in this particular case, I think it's GTTG Broadway. It looks like they had a hearing and were found in violation. So my question is, this hearing was in July, so I'm thinking it was part of the packages that we did.
It may have been on summons.
Okay, but my real question is, in that hearing, if a respondent comes forward, meaning before the special meeting, and they present circumstances or they inform you they're looking for a contractor, would customary practice be to adjourn the same way you would do in a special hearing? Or, you know, because they're taking steps to come into compliance?
Well, yeah, so for example, we have this package was 10. Until we found out right before the hearing that one of the buildings had actually just come in and renewed their permit. With the ones that defaulted in the first round of hearing dates, when I went through those with the Bureau, it turns out that one of those, even though they defaulted as to the cease and desist hearing, has come into compliance. So we will be checking these, obviously, before we do anything, to see if they come into compliance. And at the December meeting, we probably will be notifying the board as to a small number of cease and desists that we, even though they did not show for the hearing, we are aware that they are now in compliance, so that those orders can now be, closed out. They're no longer.
Yeah, does that address it?
Well, I guess what I'm concerned about is people who are taking steps towards it. Right? Because my thought is, if in a special hearing, a person can say, I'm looking for a contractor, or I'm taking these proactive steps, or not proactive at this point, it's reactive steps to come into compliance, and an adjournment will be granted. In this particular case that I'm looking at, where they were found in violation, I guess I'm making the assumption that they did not present the same type of mitigation measures, or that they're doing it. So I'm just wondering if in a normal hearing, a person is working towards compliance, would DEP have an adjournment? And I wonder why stays and assuming that this person is not trying to come into
In other
compliance.
words, at a hearing on the summons,
Yeah.
if the respondent said, we're not in compliance, but we're working to come into compliance, would the hearing on the summons be adjourned for them to come into compliance? I mean, the respondent could ask the hearing officer for an adjournment, but I don't know why the hearing officer would grant that, because the hearing itself is about adjudicating the summons. It's not about compliance.
Understood. So it's the original problem. I understand.
Just quick, Leslie, is DEP going to cut off heating service to any buildings during the winter?
Well, again, that's a difficult question. The buildings could theoretically have to get a temporary boiler to provide heat and hot water. That's going to be an issue if they're in default. Ultimately, that will be an issue that the commissioner will probably have to make the call on, like what to do. Where you have a building that has an expired permit, some of them for 5, 6, 10 years, and they're still not in compliance. Are you gonna seal their boiler in January? That's gonna be kind of a call, I think, for the commissioner.
Is there anything that this may be a HPD thing, but is there any self-help that the city could take to take it onto it to, get the temporary boiler in place before the ceiling occurs, and then try to, charge that back to the building owner through a leasing process? Is that a possibility?
I mean, I guess it's a possibility that to talk, before I think you were gonna seal the boiler in an apartment building in January, I think we would want to talk to HPD. Hopefully it's not gonna come to that with any of these ultimately. But, I mean, you know, these 40-ish buildings have been, you know, extremely unresponsive. So, you know, this is an attempt to get some kind of responsiveness out of them. And for the ones that still don't respond even to this, that's probably gonna be a call for Commissioner Agarwal to make.
I mean, I just do want to say that it's troubling to think that there's a possibility of folks needing to vacate their homes in.
I mean, if it came
was
down
all
to
gonna
the building having to be vacated or not sealing the boiler, I'm pretty sure that the commissioner would come down on the side of not sealing.
And this was why we were hoping to do all of these earlier,
Right.
but we have to space them out for, you know, for our own hearing purposes. And so, but it's, the concern you're raising is what I think others here raised when we first started hearing these cases.
And I think also from the few that have showed up so far and have been adjourned, it looks like that these buildings, some of them are gonna need quite a bit of work done. We just had one on Tuesday that was adjourned based on the work plan that they had. The hearing was adjourned until February because they have to replace the chimney and do a whole bunch of other stuff before they can actually convert the boiler. So these may not be the 40 best apartment buildings in New York City. Let's put it that way.
But it's promising to hear that people are showing up, they're explaining these are the steps that we're taking, and that is allowing for a pause in the enforcement process.
And there is something they can do because they can get these temporary boilers. It's very expensive, but,
That's the thing. with
but
companies.
yeah, but landlords, you know, have a way to remediate it if they're.
Yeah, I mean, as long as they show up and say credibly that they're doing something, like with the one on Tuesday, where they came in and submitted a plan that indicated that everything will be completed by the end of February. And, you know, the judge, the hearing officer adjourned it, thought it was fine, and we didn't object to it, because again, if they submit something credible and that's what it's gonna take, it's gonna take until February. That's what the contractor says. The idea is to get them into compliance, and since they've already mostly not been in compliance for years, if it takes them 4 or 5 or 6 months, then fine.
I was wondering if I could request, or Commissioner, if we could request that the department, our next meeting, report sort of on the status of these, just so we can have an understanding as a board when we have to vote on the next batch of how they're working through the process. What the implications are proving out to be,
Yeah, I think we can do that. The first batch that was approved in June have had their hearing dates. The second batch that were approved in August have not yet had their hearing dates. So I think for the December meeting, we can.
Be great. Thank you so much, Russ. Other comments or questions? Okay, well, again, thank you all for the questions and the thoughtful discussion on this issue. So with respect to the 9, am I correct? 9 cease and desist orders that Russ read out is the record by name. Could I have a motion to approve the cease and desist order requests? Okay, see a motion from that and a second from that.
Are there any objections to the motion approving the cease and desist orders for the 9 respondents with expired certificates of operation to use the report table with? Seeing none, hearing none, motions carries.
Okay, Russ, thanks again to you and your colleagues for all the work that you're doing on this and your responsiveness to the questions of the board. Okay, I'd like to ask for a motion to go into executive session. See a motion from Matt, and Lisa.
Are there any objections to the motion to go into executive session? Seeing none, hearing none, motions carries. Okay.
Okay, hold on while I get ready for executive session.
Okay, we're back in public session. Does anyone have any other questions or business to raise? All right, then let's discuss possible dates for our next meeting. We'd like to propose either December 5th or 12th. Does anyone have any objections to either of those dates?
I'm away on the 12th.
Okay. Everyone okay for the 5th? All right, let's put down December 5th for the next ECB meeting, and we will get calendar invites for that as usual. Could I please have a motion to adjourn the meeting today? Okay, I see a motion from Mr. Schmott. I see a second from Matt.
Are there any objections to the motion to adjourn the meeting? Seeing none, here's a motion carried.
Okay, today's motion is adjourned. Thank you all very much, and we will see you next after the Thanksgiving holiday. Thank you.